Okay, welcome back, everyone. We're continuing with our panel on property, personhood, and rights. There we go. And we have Joshua Jowitt here with us, who's gonna be talking to us about the miracle on Eagle Street. Josh is a lecturer in law at Newcastle University. He works primarily in the field of contemporary natural law with a focus on ethical rationalism and the consequences of this approach for inquiry into the nature of legal normativity. He's also a Jowitt, but I don't think he wanted me to mention that. On a more practical level, Josh is interested in the concept of legal personhood and the extension of legal rights to non-humans. Josh's work on the latter topic has recently enabled him to take up visiting positions at the Max Planck Center for Comparative Public Law and International in Heidelberg, and at the Cambridge Center for Animal Rights Law, where Josh stayed with us earlier this year. Josh, thanks a lot for being here.
Don't clap first, you'll regret that. Thank you, Sean, and thank you, Raphael, for inviting me to join this conference. And I think on behalf of everybody, I want to say thank you for the incredible amount of work that's gone on behind the scenes to make this happen in person, because you can get a lot from the Zoom events, but I don't know about everybody else, but I realised last night in particular, it's the informal meeting and over drinks and over dinner where a lot of the really meaningful connections happen, and the Cambridge Centre's always been really good for that. So thank you for making this happen. It's been really, really valuable. Okay, so today's talk, I'd like to dedicate today's talk as well, in light of the generosity of the Centre yesterday, to paracetamol. Because without that, I would not be stood here today, let me tell you. So thank you, paracetamol. Today's talk is entitled Miracle on Eagle Street. And that was a deliberately obtuse title that I picked. I tried not to give too much away to try and hook you all in. So I'm going to begin by just explaining what the hell the Miracle on Eagle Street analogy actually is and why it's relevant for an animal rights law conference. And if you're particularly astute, or God forbid even read the abstract, you might have noticed it's an analogy to what a colleague of mine thinks is the greatest legal drama ever written, which is this movie, Miracle on 34th Street. Has anybody not seen Miracle on 34th Street? Oh my God, what is wrong with you all? Put it on. Spoiler alerts then. Okay, so if you're watching this online, stop now. Spoiler alert for the film. This film is about a man, you can see here, played by Richard Attenborough, called Kris Kringle, who believes that he is Santa Claus. And he lives in New York City, and there is a rule in this film that exists in the state of New York that says, if you believe yourself to be somebody that you are not, then definitionally, you are insane. You just are. That's the rule. But the Judge Henry Harper, is really uneasy with this, because he's like, well, I can't ruin everybody's Christmas, can I? Like, and convict a guy called Kris Kringle on Christmas Eve. I can't do that. So he's looking for a reason to try and let this man off. And they call all kinds of experts to the courtroom, and there's an Air Force general, and they ask the Air Force general, have you seen anything over the North Pole? And the Air Force general says, no, we've done lots of flyovers the North Pole, we've never seen a thing. And Kris Kringle's like, well, that's because the workshop's magic, duh. Like, of course you can't see it, it's magic. So the judge is really trying, but he's not getting anywhere. And eventually what happens is a small child goes up to him and gives him a dollar bill, gives the judge a dollar bill. And on an American dollar bill, you have the words, "In God we trust." And this is when Henry Harper has his eureka moment, and he says, aha, this is the reason I need here. I can have my own faith and my own belief and bring in my own sense of fairness here, because we do that with money every single day. Money's not real, it's a fictional thing, but we trust in it. We trust in it because it has value to us. And he applies that logic then over to the idea of Santa. He says, I don't care about this idea of whether it's real or not real. Let's go for the greater good here. And he lets Kris Kringle off, and Christmas is saved. Hey. Thank you. God, it's a tough crowd here, isn't it? My God. So basically, behind the whimsy, I think there's a serious point being made here. There's a legal rule. The judge knows the legal rule is unjust. He feels bound to follow it until he finds a reason to disregard that particular rule. And that, I believe, is exactly what is going on with the case of Happy the Elephant, currently working its way through the court system in New York. And it's currently lodged in the Court of Appeal, which is on Eagle Street in Albany. You see what I did there? We're going to get a miracle on Eagle Street. So this talk then is going to be examining Happy the Elephant's case so far. This talk, I'll just give you a bit of context about what this paper is designed to do. As Raphael alluded to, normally I try and club you around the head with a remorseless logic a la Alan Gaworth. And when I first came to the Cambridge Centre in January as a visitor, that was the approach I wanted to take to this paper as well. And Sean and Raphael gently said, Josh, people don't like being clubbed to death with logic. Try and bring them with you. Try a more subtle approach that maybe would persuade people who are not inclined to your very strict way of thinking to come with you and not put them off. So that's what this paper is trying to do. It's a fairly new approach for me because I do like clubbing people to death with logic. But here we go. I'm going to take you along this particular path. I'm going to begin this talk today by introducing you to Happy the Elephant's case, the progress we've made so far, and some key excerpts from the judgments that have been heard to date. What I'm then going to do is introduce you to a little bit of theory. I'm going to give you Gustav Radbruch, and I'm going to tell you why Gustav Radbruch will give the judges the reason they need to depart from the rule that currently prevents justice for Happy. And then having done that, I'm going to move on to show you that this is not actually particularly novel or exciting at all, because the common law is very well suited to the expansion of rights in the way that I'm arguing should happen. And as an aside on that particular point as well, the rule you'll soon realise is to do with legal personhood. All things in animal rights law are ultimately down to legal personhood. I'm going to argue that legal personhood is literally irrelevant to this case. The common law cases I'm going to show you in the third part are also concerned with beings who historically had legal personhood withheld from them or granted on a very fractional level. And in the cases I'm going to introduce you to, the court said this is literally irrelevant. We shouldn't get bogged down in the legal status of the individual. What matters is the justice for the individual. And that's what I'm going to argue, I suppose, should happen here. And then the best outcome will be Happy will get her miracle on Eagle Street. That's the Court of Appeal right there. Lovely building. Playing for time now. Cool. So, meet Happy. I'm going to presume most people know about the case of Happy the Elephant, but if you don't, here she is. Let me just tell you right now, Happy is not Happy. It's a very misleading name. We don't really know even how old Happy is. We think she's in the late 40s. And she was taken from the jungle in Thailand with 6 other calves in the late 1970s, sent to America, and worked for the first few years she was there in a travelling zoo. Eventually, she was taken from the travelling zoo and placed permanently in an exhibit in the Bronx Zoo in New York, where she's lived ever since. She originally had a companion animal with her, but her companion died in 2006, and she's lived there on her own ever since. An irrelevant thing here is that elephant experts believe that the conditions that Happy are kept in are directly linked to significant physical and mental health risks, and that the isolation in particular is a contributing factor to this particular harm for Happy. And this has all been accepted by the court. The courts are happy to say that there's a direct causal link here between the conditions and the negative health consequences for Happy. This case first hit the headlines when the Non-Human Rights Project, which is a civil rights charity that exists in the US aimed at giving rights to non-human animals, decided to take it on in 2018, and they filed a writ for habeas corpus in the state courts of New York. Now, this went to the district court, the lowest court in New York, and they basically said, look, we might be sympathetic towards this case, but we are bound by precedent. The case of Tommy the chimpanzee that was alluded to in the previous talk says quite clearly that, amongst other things, this is an issue for the legislature. The New York courts should not declare legal personhood for animals, which would be, they say, a logical necessity of granting rights, because the question of legal personhood is just too big a topic. The legislature needs to deal with it. And the courts then have been bound by this rule since the Lavery case. And they've cited it in Happy's case to date. Most recently, the hearing on the 17th of December, which was the most recent appeal, said quite clearly, we're bound to follow the precedent that exists in Tommy's case that says this is something for the legislature, end of. But it's now before the New York Court of Appeals, which is the highest court in the state of New York. David, I'm sorry I forgot to change this since the SLS in Durham. This last claim is a little bit inaccurate. This is not the first time an animal rights case has got to the top court in an English-speaking jurisdiction. It's the first time a habeas corpus claim for a non-human animal has got to the highest court in a non-English-speaking jurisdiction. it's not any less impressive, I think, for that. It's just slightly more specific. It's not like me telling you, oh, I once won an award when I was 18 for making the best latte in an Italian-owned coffee shop in Barnsley, which I did. Thank you. but that's less impressive because there is only one Italian-owned coffee shop in Barnsley. This is a big claim still, and it's a big claim because the Court of Appeal for the first time can abandon this precedent. Precedent operates in the state of New York very, very similarly to how it operates in the English and Welsh jurisdiction. The courts are bound to follow any decision of a higher court. There is no higher court than the Court of Appeal, so they can, for the first time, choose to disregard this if they want to. The default position, I'm told, is that they would probably stick with the precedent unless they have a really good reason to follow it, which is why, they have a really good reason to abandon it, which is why I'm hoping to give you that reason today. And the whole point of this paper then, based on the conversation I had with Raphael and Sean at the visitorship that I undertook here, is to say that the courts have already acknowledged every single relevant reason that they need in the lower hearings. Okay, so based on the court's own logic of what they've already accepted as fact, they already have the reason they need to discard this precedent. So the first thing I'm going to show you to is the judgment in the district court, which is the first lowest court in the state of New York, and it's a judgment of Alison Tuite. And Judge Tuite said in this case, the precedent I feel bound by doesn't actually tell me that this is a good or a bad argument. It just says it's not one I should consider. And she then went on to speculate a little bit, and the quotes there show you what Justice Tuite did. She said, Happy is a complex being. She's an intelligent being, has very, very complex cognitive abilities with advanced abilities akin to human beings. So she's kind of drawing a direct parallel there with the fact that we, as human beings, are able to enjoy habeas corpus because of our advanced cognitive abilities, and Happy also possesses those same advanced cognitive abilities. She's setting you up there for a simple exercise in deductive logic. Right? This is nothing particularly difficult to follow. It's very, very traditional formal logic for lawyers to do. We as humans are capable of benefiting from habeas because of our cognitive abilities. Happy has the cognitive abilities, therefore Happy should benefit from habeas corpus. That's the road that Judge Tuite's trying to take you down. What's interesting though is this judgment was appealed. And the most recent judgment that I alluded to earlier, back in December, didn't touch on the merits of the case at all. This was an insulting judgment to read, frankly, because it was only 15 lines long. Contrast Justice Tuite, who just a few months before had gone into intricate detail saying, look, there's a real claim here. This is not frivolous. There's a legitimate claim for habeas corpus for an elephant that we as a court have to take seriously, just not me, because I'm bound by the precedent I'm not allowed to. The Court of Appeal, nothing. Just we are bound by precedent to discard this case as frivolous. It was ridiculous. So I'm saying then, based on what Justice Tuite said, this is a terrible outcome so far, and now that the courts do have a chance to move from it, they need to acknowledge this elephant in the room, elephant in the courtroom, probably would have been a better pun there, but acknowledge that Justice Tuite was on something, give the case the credit that it deserves, that the lower courts have acknowledged already it deserves, and go to what I think is the only logical outcome, which would be to grant the habeas relief for Happy. Now, so far so good. You might think, Josh, you're preaching to the converted in this room. We still need to give the judges a reason here, right? The Court of Appeal seemed quite firm in saying they didn't see a case. The 15-line judgment suggests that they thought there was no relevant argument here. So why suddenly should you think any different? Well, this is where Radbrook comes in. So if you weren't expecting a legal theory talk today, then I'm really sorry. You can switch off for the next 5 minutes because that's what you're going to get. Now I'm going to give you a brief overview of why Gustav Radbrook comes in. He was a German legal theorist writing in the aftermath of the Second World War, and his most famous article published in English is the one that's cited just underneath his portrait there. And the main thrust of this article is that we need to go back. When we're looking at the idea of whether a judge should follow a rule in a particular case, let's take a step back. Look at what a judge actually does in the courtroom. What kind of things is a judge even allowed to consider as part of their role? And Radbrook says there are 3 things that judges inevitably consider whenever they're adjudicating any legal dispute whatsoever. They necessarily have to look at the idea of legal certainty. It's a judge's duty to make sure that the law is stable and certain and people can plan their lives accordingly. But judges also need to look at the idea of the justness of the rule, the fairness of the particular rule in question, and they also need to consider whether or not enforcing the rule or the otherwise existence of the rule would maintain some kind of public benefit. Now, Radbrook says those three things, those three judicial virtues, exist in a hierarchy, with the prioritization of legal certainty being the most important, justice and fairness of the rule being somewhere in the middle, and that the rule be of the public benefit right at the bottom. So Radbrook's default position then is that you can have a really, really unfair, unjust rule, but if legal certainty requires that we uphold the rule, then we should still uphold the rule. Okay, so it's kind of a positivist claim there that he's making. Look, the rule's there, it's certain, it's clear, there's no doubt about it, so even if it's unfair, we kind of have to apply it. But, and this is where it gets interesting, but he says that some rules are so unjust and so unfair that they actually serve to undermine legal certainty. So if a judge's primary role is to maintain legal certainty, and they're faced with a rule that's so unjust it destroys legal certainty, they actually have to ignore the rule. That rule cannot be legally binding because enforcing it would breach their primary role of maintaining legal certainty. So it's a bit of a complicated double think that Radbrook gives you there, but he tries to show then that these particularly unjust rules should be discarded if they undermine legal certainty. So what might these rules look like? What kind of rule are we looking for here? He tells us. He says, these rules tend to be ones where there's not even an attempt at justice, where equality, the core of justice, is deliberately betrayed in the issuance of a positive law, a rule. Then the statute is not merely flawed law, it completely lacks the very nature of law, and judges should actively avoid enforcing these particular rules. Okay? So he says then that the key example of a rule that should be discarded as undermining legal certainty would be one that fails to treat like cases alike in a legally relevant manner. Because by failing to treat like cases alike, you're undermining the very purpose of the rule, which is to apply evenly to all similar cases. Therefore, discard a rule that doesn't treat like cases alike. Everybody with me so far? Yeah? Some people, though, out there are not with me. They'll be saying, Josh, I'm a legal positivist. This all sounds horribly moral to me. Why should I be on board? Looking at you, Ava. Right, why should I be on board with this? Well, I think HLA Hart, of all people, gives the reason why a positivist should be on board here. Now, HLA Hart is an English legal theorist, and one of his big contributions to the idea of judicial deliberation was on whether and when judges can take morality into account in their decisions. And he said we need to look at the rule again. Look at the nature of the rule. If the rule's really clear and obvious, then of course a judge can't take morality into account because the rule's clear and obvious. But if it's not certain whether the rule applies in this particular case, if there's any ambiguity whatsoever, then the judge can then, if he wants to or she wants to, bring morality in and say, look, let's apply fairness here and look to the reason behind the rule and ask whether or not fairness and justice can help us decide whether or not this rule applies to this situation. So in Happy's case, a Hartian would be saying, well, is this a penumbral case where we don't know whether this rule applies anymore? And I think it is. And Eva, I did some maths. Right? I actually went on the New York Court's website and saw what percentage in the last 3 years of cases were actually accepted to be heard by this particular court. And for the most recent statistics that we have available to us, this is a 3-year average, only 3.4% of cases that were submitted for appeal were actually heard. That's gone down from the previous 3-year average, which was 5.2%. So I think, based on the court's own terms here, the legal officials in the state of New York clearly think that this is a penumbral case that's worthy of deliberation, otherwise they literally wouldn't have heard it. That statistic is so low that they would not have even agreed to hear this case if they did not think it was a penumbral application of the rule. So all you positivists out there, here's your reason why we should take Radbrook seriously, because Hart says we're allowed to. Okay? Talk to me about that later if you want. I know that's probably the controversial claim I make today, so we'll talk about that later. But let's bring it back to happy. What we need to do now then is ask ourselves, is this rule so unjust in treating like cases differently that it undermines legal certainty? Because if it is, then now the judges have the reason they need to refuse to apply this rule. And this is where we bring it back to Justice Tuite, who I mentioned earlier, the first court, the first hearing in front of the divisional court. Remember, she said that happy does seem to be legally relevant to human beings in that we are cognitively similar, we have advanced analytical abilities, and that's why we seem to possess a claim to habeas corpus. So if happy possesses the same claim, it's simple, formal, deductive logic. This is nothing like big inferentially here going on. We're not even drawing an analogy. We're simply comparing the legally relevant status of two beings that possess the same legally relevant status and saying, well, treat them the same. They both are capable of bearing the right to habeas corpus. And although she did dismiss the case because she felt bound to follow the precedent and defer to legislature, she literally said, I only do this regretfully. And I think that word's doing a lot of heavy lifting in that judgment. She's saying, I know that this rule is bad. I know it's not treating like case alike, but regretfully, because of the operation of precedent, I just have to follow it. I'm bound. And she's not the first judge on the bench of New York to express reservations about non-human rights cases being dismissed in this way either. I'm sure a lot of us will be familiar with the Fahey concurrence, Judge Eugene Fahey. The last time the court in New York heard a non-human rights case about Tommy the chimpanzee, wrote a concurring judgment. And in this concurring judgment, he did say, I really struggle with whether or not our rejection of these claims is the right approach to take. And he says at the bottom, look, it might be arguable that a chimpanzee, this in the Tommy case again, remember, is not a person. It's definitely not a thing. There's definitely a legitimate claim here that the court needs to respond to in some way. And elsewhere in this judgment as well, he again, like Tuite did in Happy's case, took great efforts to compare non-human animal mental capacity with human mental capacity, and showing that the foundation for habeas corpus, again, was found in that shared mental capacity. So Fahey, I think, also sees treating like cases alike here to be a relevant legal issue. And the reason I'm spending so much time talking about a chimpanzee case, when I told you I was talking about an elephant, is because Judge Fahey is going to be on the panel that hears Happy's appeal. He's going to be sat on that particular bench, so he has already expressed these opinions before. He knows that this rule fails to treat like cases alike. So the onus is on him to do something about it. The key issue then that both judges have accepted is that there is a problem of injustice by inequality that definitely exists in Happy's case. They have accepted that the whole point of habeas corpus is to protect freedom. They have accepted that Happy has the capacity to benefit and enjoy her freedom. Therefore, maintaining this unjust rule does not treat like cases alike, and the courts have a very good reason to disregard it. And we now move into the final part of the talk then, where I'm saying this is not necessarily revolutionary. The courts have already in the past rejected cases where the rule was unjust because it differentiated between the legal status of individuals. The two cases, just to give you a brief content warning here, I'm going to be discussing. One's going to be about rape within marriage, and one case I am going to be discussing the status of slavery in law. So I'm just letting you all know that again, people watching online, if you want to switch off, I am going to be talking about those cases now. So the first case I'm going to discuss where I think the courts are doing what Radbrook would have accepted as the only reasonable course of action is a famous English case called R&R. Any non-lawyers in the room? Okay, so you all might be shocked by this case in particular. Look at the date of this case. This happened in 1991. The facts were as follows. There were a husband and wife who were separated and intended to get divorced. The divorce had not yet gone through, but the intention was there. The man broke into the house where his wife was staying and had sex with her against her will. He raped his wife. He was initially convicted at trial of rape, but this went on to appeal. And he said, look, in law, there is a defense available to me. Because we were married, I legally cannot rape my wife. We're married. And that rule existed. There's no claim that that rule didn't exist. This rule was valid in English law up until 1991. The foundation of this rule was that when the wife entered into a marriage contract with her husband, her separate legal personality was expunged, and a new legal personality was created where the husband and wife were one person in law. That's clearly nonsense, because what actually happened is the husband absorbed the wife's legal personhood. There was no person created. The husband absorbed the wife's legal personhood. So that was the twisted legal logic behind this. The woman's legal personhood was at best now fractional. It didn't exist in a separate sense. Therefore, she couldn't be raped because she didn't exist as a person in law. Now, the Court of Appeal and then the House of Lords said this is absolute legal nonsense. And they said, Mr. R, we are upholding your conviction of rape, even though this rule exists, which means you should have got away with it. And the reasoning they gave, I think, is fascinating. They said, we are not retroactively criminalizing this. We are not punishing this. We're not creating a new offense of marital rape. We are removing, this is a bit in bold, a common law fiction, which has become anachronistic and offensive, and that we consider it is our duty, having reached this conclusion, to act upon it. That, I think, is acting in exactly the way that Radbrook would have wanted us to behave in this case. They are saying here quite clearly, this rule that differentiates or subsumes the legal status of the woman into that of her husband is immoral. It's repugnant because it fails to treat like cases alike. Why is the status of marriage a relevant characteristic if you've been raped? It doesn't matter whether you're married. The legally relevant fact is you've been raped. So get rid of it. This is not a valid legal rule. It never has been a valid legal rule, and we are removing this common law fiction. So it's an unusual case, I think, for me to bring into this talk, but I think it's one that really, really holds water. The last case is a famous one in animal rights circles, Somerset and Stewart. And again, in this case, we have a status of a slave. James Somerset was purchased as a slave by Charles Stewart in Boston in Massachusetts. He was taken to England, to London, where he lived for several years, but then Mr. Somerset escaped captivity. He was recaptured and was going to be sent back to Jamaica to be sold at a slave auction. Now, the anti-slavery movement got wind of this and submitted a claim for habeas corpus on behalf of Mr. Somerset and said, you cannot deport somebody against their will. The slave owners said, but this is not a legal person. This is a slave, and in law, they are property. That's the end of it. I can do what I want with my property. The fact that they might seem like a natural person is not relevant. And Lord Mansfield said, no, it is relevant, right? You cannot deport somebody against their will. And if we allow this person to be deported just because they happen to be seen in law as property, then who else are we going to deport? Right? The whole idea that you can't be deported against your will get eroded because of this. Okay? So this case didn't actually challenge Mr. Somerset's status as a slave or property whatsoever. It just said that the idea of justice in this case needs to take precedence over that property status, which again, is again what I'm saying should happen in Happy's case. Right? The question of whether or not Happy is property is legally irrelevant. The only legally relevant fact that the court needs to decide upon is she capable of benefiting from a writ of habeas corpus? And the clear answer there is yes. So to conclude then, one of the reasons why the Non-Human Rights Project is using the writ of habeas corpus in cases involving non-human animal rights is exactly because judges do have discretion to abandon rules that they see as unjust. The judges in Happy's case have already acknowledged that there are merits to the legal claim, but have only dismissed it because they're deferring to the legislature. This rule is unjust because it fails to treat like cases alike, and Radbrook then tells us they should disregard the rule, which is a typo. And this is something the courts have done in the past. Right? The courts have extended personhood in the past when they've recognised a moral imperative. that imperative exists here. They should do it. So thank you for listening, everybody. I think I've gone a bit over time, but if you want to carry on, email me, follow me on Twitter. Only follow me on Twitter if you like hearing my thoughts on RuPaul's Drag Race, because that's mainly what I tweet about. But thank you very much, everybody. Happy to carry this on.